Hello.
So good evening.
Good evening.
So I, on behalf of BeyondLawCLC as well as UILS Punjab University Chandigarh, welcome you all to yet another session which will engage us in a different way. We have a topic which invariably lawyers are not keenly taking up. They find just hold on. Is everybody able to hear it? Kindly post it on the chat box because I've just received from Mr. Sanjay Nahar that he is not able to speak. And if Mr. Badrinath, could you just try the disallow the annotation, because otherwise some people have started scribbling it out.
Disallow the annotation.
Just try the stoppage of annotation. Oh.
But you're not.
Yes, sir. We can start. Everybody saying we are able to hear. On behalf of BeyondLawCLC and Punjab University Chandigarh, we welcome you all to yet another engaging session, wherein we have taken the topic of GST, a product of collaborative federalism under Indian Constitution, and a topic which looks very complex, but we have a person who is known for making complex issues simple, and he's from the firm Lakshmikumaran and Sridharan attorneys, who have created a niche wherever the issues of complexity, not only of direct and indirect tax comes, but large issues which are of wide spectrum. Their firm is contacted, and under the aegis of Mr. V. Lakshmikumaran, they have been able to lay down the benchmarks which other people need to copy so that they can also reach those benchmarks. Be that as it may, in the competitive world, it is always that once you are on the, it is said that it's not difficult to come on the top, but it is difficult to sustain on the top. But Mr. V. Lakshmikumaran has been able to sustain, create different benchmarks. Once, if one Googles on the Google, one finds that they have more than 400 associates and more than 12 offices. That itself is not a mean achievement, because we find that even to sustain one office with 10, 12 people, it becomes very difficult. The topic, once it came, there were a large number of jokes spread on GST itself, because people were finding that GST is not easy to understand. But, and invariably, chartered accountants taking up these issues, but this firm has shown us a new horizon that the lawyers can also do a complex issue. Amongst us, we have Professor Ratan Singh, who is the director of UILS Punjab University Chandigarh, with whom we have the partnership where the intent is to disseminate knowledge through the speakers who are legally known for their acumen as well as the ethics and principles. I would ask Professor Ratan Singh to formally welcome Mr. V. Lakshmikumaran. So it's a proud moment for BeyondLawCLC as well as UILS Punjab University Chandigarh to have you on the board. Over to Professor Ratan Singh. I'm just unmuting Mr. Professor Ratan Singh. Yes, sir.
Yeah, thank you, Vikasji. Thank you very much. Vikasji, once we are talking about the federalism, and over this we have long provisions as far as the constitution is concerned, which are dealing with the center-state relations. Even though for this, a dispute right from the commencement of the constitution till today is going on. Sometimes it was some financial matter, sometimes it was administrative relations, or it may be a legislative relation between center and state. We have constituted Sarkaria commissions, and the Sarkaria commission has given detailed recommendations. And after Sarkaria commission, again, the Constitutional Review Committee was constituted for giving recommendations to see about the center-state relations. But the topic which we have chosen for today about goods and services tax, a product of collaborative federalism under the Indian Constitution. Because reason being, in these days, the issue between center and state is coming up at with reference to GST. Because reason being, GST is determining about the true character, whether this is a unitary state or it's a federal state. So I hope with the deliberations of Mr. Lakshmikumaran, there will be a lot of doubts among the academicians, among the professionals, and I'm very sure his deliberations will definitely enrich us, and this will be the feast for the day for all of us. So I welcome you on this platform, Mr. Lakshmikumaran, and back to Vikasi.
So before I ask Mr. V. Lakshmikumaran to formally take over the entire issues and to elucidate in his own style and to explain, we will be having question and answer session after the entire bird eye view of this GST, a product of collaborative federalism under Indian Constitution. But we will just like to clarify that since the topic is a very limited issue on a GST, a product of collaborative federalism under Indian Constitution, we will be only taking those questions which fall within the gamut of this issue, because the subject is vast and let's not elaborate it more, and we will not be able to handle everything. So we are all participants having good knowledge. We should restrict ourselves to this. Over to you, sir. Thank you.
Thank you, Professor Ratan Singh, and also to all of you. Good evening. Normally, a Saturday evening is a time where you spend time with your family. And in these COVID-19 days, we are spending time on learning something new as subjects. When Vikas spoke to me whether I could share my thoughts, I was too happy to do so. And I have taken a topic which is very interesting and I would say, I won't say controversial, but it is necessary. What I intend to do today is we will first of all give a very short glimpse of the salient features of the GST. We would then deal with the famous Constitutional Amendment of 101st Constitutional Amendment. And then I'm going to describe how the collaborative federalism is working under the Indian Constitution and how the GST is born and flourishing. That's what I want to talk today. When you talk about the salient features of GST, what comes to your mind? We had in the past several types of taxes, excise duties, service tax, central sales tax, etc. Each of those taxes are all event-based. The event of manufacture attracted excise duty. The event of rendering services attracted service tax. The event of sales attracted sales tax. Event of imports attracted custom duties. So what is the taxable event as far as the GST is concerned? It is the supply of goods or services or both. And this concept of supply is not necessarily related to sales, it's much beyond. And we can write treatise on the term supply, and any book will be incomplete on dealing with subject of supply alone. Now, this is not the lecture for dealing with the word supply. I restrict my curiosity to talk more about the supply today. However, as far as India is concerned, it was having different varieties and types of taxes. I was just mentioning excise duties, service tax, central sales tax, countervailing duties, special additional duty, state value tax, entertainment tax, etc., etc., etc. All these taxes are getting subsumed in one tax called goods and services tax. We must remember, custom duty has not been subsumed in the GST. The import and export of goods will continue to be governed under the customs law and the custom tariff. The import policy, export policy will continue to operate. Whether GST or no GST, custom duty will be charged on the import and export of goods. The most important feature of the GST is the grant of seamless credit. What I mean by seamless credit is, for those who have been practicing this tax of value-added tax, they will remember that if VAT, or then called sales tax, if it was paid in Maharashtra and the goods are sold from Maharashtra to, say, Karnataka, and in Karnataka, if the goods are resold, there is no credit of the taxes paid in Maharashtra. It was not available. Therefore, it becomes a cost. So every time when the goods move from one state to another, the taxes paid in the other state was never given as a credit while paying taxes in the second state. And if, unfortunately, if those goods are again sold to another state, you add another component of the interstate sales tax without any credit whatsoever. But that has been given up. Under the GST today, whatever taxes are paid at the GST in Maharashtra is available as a credit while paying taxes in Karnataka. Honestly speaking, as a lawyer practicing taxes for more than 30 years or 35 years now, I never imagined that this could happen in India, considering the way in which the states were following the taxation policies. Karnataka used to think, why should I give a credit of taxes paid in Maharashtra while I am allowing you to sell the goods within my state? This was the position, and we took it for granted. And I would say that this GST, this one benefit which has been given to the entire industry, that the taxes paid in one state will be given as a credit in another state, is a singular achievement as far as this particular feature of GST is concerned. We are, at this point of time, remembering what exactly happening in the European Union, where a number of countries have joined together by Treaty of Rome, and they come together and come to an agreement that taxes paid in one state, one country, is available as a credit in another country. As far as India is concerned, we are blessed. Our states are bound not by treaty, by the Indian Constitution. That Constitution binds all of us. And that Constitution is giving us the birth of GST, which is a celebrated major tax reform ever done in India in the indirect taxes field. And this GST also brought about a very paradigm shift in the way of thinking of the indirect taxes. Earlier, sales tax, etc., were origin-based taxed. Today, the GST is destination-based tax. So therefore, the destination country or the ultimate state where the goods are ultimately destined, they would get the credit and they will make the further payment of taxes. This is a singular achievement as far as the destination-based tax. Now, as far as the GST is concerned, ideally, center could collect this tax as a GST and distribute the same to the states, in which case there will be no difficulty whatsoever. However, the states did not probably agree because they don't want to lose the taxing power, nor would they want to be at the mercy of the center for getting the distribution of the taxes. So therefore, what happened is these taxes, which would have been collected by one agency at the center of the state, was not permitted. And therefore, they brought in a concept called central GST and the state GST, apart from union territory GST. Whenever the goods are sold or supplied within a particular state, those goods will attract both CGST and SGST, that is Central State Act, Central GST and State GST. However, if the goods are sold interstate, say from Maharashtra to Karnataka, in our example, then the tax will be IGST, they're called Integrated GST. And this will be paid in Maharashtra. However, when the goods are resold in Karnataka, this IGST will be given as a credit, and therefore it does not become a cost to the seller who is reselling the goods in Karnataka. This is the salient feature of as far as the GST law is concerned. Of course, we have different rates, 0 rated, 5%, 12%, 18%, 28%, plus. And these rates depend on the classification of the goods. And to appropriately classify the goods in different headings, attracting different rates of taxes is a mammoth task. Unless you are very good in technology, understanding the technology and the principles of interpretation, you can commit mistakes. That way, the law is not that simple. While doing so, alcohol for human consumption has been kept out of GST. For the present, some petroleum products like crude, diesel, petrol, natural gas, etc., are kept out of the GST for the present. But on the recommendation of GST Council, it can be introduced later. All these changes, these legislations have been made consequent to the amendment made to the Constitution, which is 101st Amendment to the Constitution. We are now going to discuss the Constitution Amendment itself. I want you to know, today I am not giving a talk on GST. That is a vast subject, interesting subject, complicated subject. But I must say, before I get into the constitutional issues, I must say, the demand for providing quality service and advice and also litigation in the GST is mammoth, immeasurable. The number of clients is more than 1 million. And I don't see many lawyers providing this service to the clients. For somehow or other, the lawyers have not spent time in understanding this particular law. I would earnestly request the lawyers in this audience take up this particular thing seriously, and they can render human service to the clients. Now, coming to the 101st Constitutional Amendment, I want to give a background. If we want to achieve one nation, one tax, as the Honorable Prime Minister said, what is that we need to do? First of all, we must freeze the rate of tax to be levied by different states. The procedure for collection should be uniform, and the taxes paid in one state should be available as a credit in another state. I think these are the fundamental things. If it is not done, if each state can tax commodities and services differently, and the credit flow is not seamless, and the procedure to be followed for paying the taxes are going to be different, then chaos, total chaos. So therefore, if you want to achieve one nation, one tax, there has to be an understanding and indeed agreement among all the states and the center that we shall follow a uniform law. Whether it is by one state or another state, we will have the same type of procedure being followed. We shall not charge different taxes rates for different goods and different services from different states. We shall follow uniformity. So these are the things which are necessary for the implementation of the GST And this is the vision of the government, where they try to bring this particular vision into force. Now, I want, before I talk about Article 246A of the Constitution, which is a new article introduced for the introduction of the GST in India, I want to give a certain background. As far as the Indian Constitution is concerned, the powers of legislation by the center and the states have been divided into three lists: union list, state list, and the concurrent list. Union list gives the power, exclusive power to the union to legislate. There are about 97 items in it. As far as the state list is concerned, it is giving the power to the state governments to levy or legislate on those subjects. Then there is also a concurrent list where the center and the state could exercise the legislative power to those subject matters. And if there is an incongruity between the, or conflict between the legislation by the center vis-a-vis the state, then the central legislature will prevail. The dichotomy is settled like this. So now, and secondly, any item which is not covered under list 2 or list 3, that is state list or the concurrent list, will automatically go to central list under 1897. So therefore, if you look at the federal structure of our India, it will look though it is federal, but is tilted toward the center. In fact, there are judgments also to say that, to that effect. Now, whenever you are going to talk about the GST, where the power of legislation, levy and collection of the GST is going to be done both by the center and the state, easily it could have been put in the concurrent list. And from the concurrent list, they could have drawn the powers to the state and the center. However, the state government probably did not agree, because the past experience that the center may not give them the fair share. In fact, this could be one of the reasons why there was a long delay in the commencement and legislation of the GST. And ultimately, the center has to sit down and then talk to the center states. All right, let us now have one article other than the union list, state list, and concurrent list, where the Constitution will give the power both to the Parliament as well as state legislature to make laws with regard to the goods and services imposed by the union of the state. This is the article called 246A, and this article specifically says, notwithstanding anything contained in Article 246 and 254, Parliament and, of course, subject is clause 2, the legislature of every state have the power to make laws with regard to GST. So the first time in India, in the Constitution, you have introduced a particular article whereby the power to levy the tax is given to both Parliament as also the state legislature. This is a unique amendment to the Constitution, giving this particular power to the state legislatures as also the Parliament. Therefore, this is not a levy where you can trace it to concurrent list. It is a levy under Article 246A. While doing so, they also said that the Constitution also says, as far as the imposition of taxes on the interstate goods, supply of goods and services, it shall not be with the state governments. It can be only with the center. Similarly, with regard to the importation of the goods, wherever GST has to be levied as the countervailing duty, it will again be by the center and not by the states. And it is for good reason. Even in the respect of VAT regime or sales tax regime, interstate sales, what will constitute interstate sale, what could be the rate of taxes paid, etc., was always by the Central Sales Tax Act and not by the state legislatures. And this has to be maintained here, otherwise there can be utter chaos. So therefore, advisedly, as far as the power to levy tax of the interstate supply, as also the cross-border supply, has been kept only with the Parliament and nobody else. Again, always Article 271 gave the power to the center to levy surcharges. And this power has been curtailed in respect of the goods and services covered by the GST. The center will not have the power to levy surcharges. And this is necessary because if the power is given to the center to levy surcharges, it can increase the quantum of the GST for the central portion, depriving the state governments. Therefore, this again brought in what is known as level playing field between the center and the state. And of course, we need to amend Article 366 by introducing new sub-articles 12A, 12 and 26A, defining what is goods and services tax, what is the event of levy of tax, and what should be the definition of the goods, and what should be the definition of services. These things are to be put in the Constitution itself. A suitable amendment has been made already. Now I am going to take up where is the collaboration in this federalism here. As I mentioned earlier, in order to have a successful and seamless levy of GST across India, and if you have to achieve one nation, one tax regime, the most important thing is the rates of taxes should be the same, method of collection more or less the same, and there should be free flow of credit. If you have to achieve that, if there is no mechanism to achieve this, there will be again chaos. So therefore, what it was thought was, let us constitute a council called the GST Council. Article 279A provides for the constitution of the GST Council. It is a constitutional appointment. This council will consist of the Union Finance Minister as chairperson, Union Minister of State in charge of Revenue and Finance as a member, and ministers in charge of finance and taxation, other minister nominated by any state government. So therefore, the GST Council is basically represented by the center by the finance minister and minister of state, whereas all the state governments are represented by the finance minister or other tax ministers, etc., as the case may be. Therefore, first of all, the council has been made under Article 279A. And then what happened? Now, one of the important articles of the GST function of the GST Council is this: all decisions of the GST Council shall be taken at a meeting by a majority of not less than 3/4 of the weighted votes of the members present and voting. This is a very important step taken. That means if any decision is to be taken on altering the rates of GST, either CGST or SGST, you need to have a minimum 3/4 weighted votes as a majority decision. If it is not there, you are not going to get the proposal approved. That is fine. But then the vote of the central government shall have the weightage of 1/3 of the total votes. The votes of all state governments taken together shall have weightage of 2/3. Here is the balance. So the center has 1/3 votes. All state governments put together have got 2/3 votes. But for any decision to be taken, you need to have 3/4 majority. So therefore, all the states put together, if they decide to do something without the concurrence of the central government, they cannot do so. The central government alone wants to do something, they cannot do so. So therefore, they have to necessarily sit together, talk to each other, persuade each other, come up with a proposal which are universally acceptable, and then go to the voting. And unless these votes, unless the particular proposal is cleared by a majority of at least 3/4 of the total weighted votes, you cannot get the proposal through. This, according to me, is the crucial aspect in the so-called collaborative federalism. We have seen in the past, as I mentioned, even the judgments of the courts, Supreme Court also said that the federalism is tilting toward the center. Here it is in balance. Now, center cannot do on its own unilaterally. State government cannot do so unilaterally. They have to sit together and then ultimately come with a majority decision of more than 3/4 decision, 75% majority, then only proposals can be cleared. Now what happens? What are the functions of the GST functions? First of all, the GST Council will make a recommendation, which are all the taxes to be subsumed, which they did. They have said the following taxes are to be subsumed, the following tax to be subsumed later. Goods and services which are subjected to the GST, that also they will indicate very clearly. And most important thing is, they said we will create model GST laws indicating principles of levy, apportionments of IGST, the place of supply, time of supply, valuation, etc., etc. All those things will be made as model GST laws. And it is expected that all these state governments will follow the model GST law, whereby we can bring in uniformity in the application of the GST. Similarly, what should be the threshold exemption for turnover for the GST? Because remember, in excise we had 1.5 crore turnover is exempt. State governments had different thresholds. So therefore, what should be the minimum threshold above which the taxes can be levied so that small traders are not put into the GST net? That also they will decide. Another thing, important decision they can take, and they have taken, is what should be the rate of tax to be levied on the goods or services. And this is a very important aspect of the GST Council's functions. This rate fixation, whether it is 0 rate, 5%, 12%, 18, 28 or beyond, have to be approved by the GST Council. If the center wants to change, they cannot change unless GST Council recommends. Any legislation by the center or the state governments without the recommendation of GST Council cannot be passed. It is illegal. It is null and void. However, the GST Council recommendations are not mandatory. The government may accept, may not accept. In other words, no legislation can be passed by the center of the state without the GST Council's recommendation in the matters related to GST. And if they do so, the legislation can be challenged. The virus can be questioned. However, it's still a recommendation. It is not binding, obviously, because the binding nature with the parliament ultimately the state legislation. So therefore, the respect is due to the supremacy of the parliament, and therefore they still stand on the recommendation. However, without the recommendation, legislations are banned. And special provision for northeastern states has to be given. And if there is any calamity, emergency, if there is any particular state has to raise revenues, etc., then the GST Council will recommend for the particular state for a particular period, you can leave additional taxes so that you can meet those contingencies. And residuary items, namely, what are the items by which GST Council can decide on their own? Now, how the GST Council was functioning all along, it is remarkable. 39 GST Council meetings have taken place till now. And all the decisions have been taken are unanimous decisions. There was no need for any voting. That means the center and the states, irrespective of the political parties sitting in each state, irrespective of the differences between the political leaders as far as the political philosophy, etc., when it comes to the question of implementing the GST, they have all decided in a unanimous manner. And they brought in a uniform GST law. And some of the major decisions taken by the council is again with regard to the policy framework. They brought in model tax laws. They brought in various rates, exemptions. And the more important thing is proactively they introduce or release those model legislations well in advance so that the state government can adopt and legislate all those things in their respective states. The most important thing is what are the important set of rules which have been released in September 2016, whereby it was finally finalized in May 2017 after getting various comments from the public. The rates have been fixed 5%, 12%, 18%, 28%, etc. by fixing taking into account the historical rates for which these goods have been taxed earlier, cumulatively, and then fixing the rate called the floor rate here. This is the rate applicable for these goods for the future, and these have been done. Apart from all, they also took into account, after fixing the rate, we the public are affected in a different manner. And if the goods are not to be subjected to a higher rate of 28% tax, the public grievances are looked into, and in November 2017, they reverted more than 80% of the goods in the 28% category to 18% category. That means they are alive to the problem. It is not as though they have rigid about a particular decision is taken, we stick by that. No, it is not the way in which GST Council functions. Example is regarding the Kerala floods. At the 32nd GST Council meeting, when the Kerala government said that they had a devastation of floods, etc., etc., they wanted to collect extra amounts, and they did. The GST Council allowed them to introduce this, what is known as the Kerala flood cess. This is another example whereby the GST Council allowed the state government to levy these types of taxes. Now, I wanted to step back here and then revisit some of the issues. As for the GST Council, as I said, is a pivot of the entire system of the collaborative federalism. The state governments and the central government have to sit down together and then discuss what is the best interest for the center and the state, and then come up with the legislations which are acceptable to the both center and the states. If today, if a question is asked, how do you manage to have the same uniform rates throughout the country for the GST rates for the center and the states? The answer is because the functioning of the GST Council. This is one step which has been taken as an important step while amending the Indian Constitution, that how the state and the center should sit together and then finalize the legislation as far as the GST is concerned. Now, I was asked by Mr. Chatrat that I would like to talk a little less and then ask more questions from the audience. I deliberately stopped here at this point of time. We can talk for hours and hours on the aspect of GST itself. But as I said, we will talk about the collaborative federalism under Indian Constitution and how the GST is born out of this particular lofty thinking. That is what I wanted to say. Therefore, I stop here for a moment and then I'll invite questions. And I would request the audience to focus the questions relating to the constitutional issues and the applicable, the law applicable to GST, rather than the GST per se, because that is a vast subject and that would require a different type of examination, etc., etc. With this caveat, I now hand over the mic to the Vikas and others.
Thank you. The insights given by you were quite lucid. You have just posted on the chat box. One is asking, Piyush, 366(29)(a) has not been deleted post introduction of GST. How do you see the conflict between this and the Schedule 2 of CGST?
That particular article ought not to be deleted. It should not be deleted. The reason is very simple. The excise duty has not been completely abolished. The interstate movements with regard to the alcohol, etc., will continue to be there, and therefore, Article 366(29)(a) must continue to be remaining there. It is not to be deleted because of the
definition is saved there. The taxable event is supply.
See, you must also realize that the definition under Article 266 is sale, whereas GST law talks about supply. And therefore, with regard to those transactions of sale that are going to talk to this, must continue to be enforced there.
The definition as such is creation.
The questions will be only taken on of those persons who have reflected their name in the chat box, because certain people have entered with the name of the mobile. Those questions will not be taken. Sridharan, why does Article 269(a) use the term in the course of import and not import?
Now, there can be situations where the goods, while during exports, can be resold by transfer of documents. The reason why it in the same words been used in the earlier also with regard to the central sales tax levy and the Cess, where they have said very clearly in the course of imports, in the course of export. And this allows not only the actual import, also allows the transfer title of the document. The ultimate buyer of the document will become the importer. And therefore, this is a facility given like this.
Ayush, what is the taxability of sales in the course of import under GST?
As far as the imports is taking place, apart from the levy of custom duties, if the goods are covered under the GST law, then the countervailing duty equivalent to interstate GST will be charged. That is the levy will be charged as a countervailing duty at the time of importation, apart from the custom duty being charged on the goods that is imported. Earlier, the countervailing duty was equal to excise duty payable on the like goods produced in India, and to some extent the sales tax levied under the various states. Now, since excise duties and sales tax are not leviable in respect of the goods covered by GST, now what will be charged will be that charge the basic custom duty, all other auxiliary duty, etc., plus now add IGST, which is equivalent to the GST payable central plus state you put together. What is the component that will be levied as the IGST at the importation?
So one person is time and again posting the question on the chat. Though I'm reading his question, but time and again I'm saying if you want to ask your question by getting yourself unmuted or otherwise, you should join with your name itself. It is Penta 8, division of tax between center and GST and the jurisdiction to recover. How do you maintain the balance?
When I mentioned about the levy of 5%, 12%, 18%, 28%, it is the consolidated amount of tax. Effectively, each of them has to be divided 50-50. In fact, whenever we say 5% GST, it means 2.5% central GST, 2.5% state GST. Similarly, when it is 18%, it is 9% central GST and 9% state GST. Now, with regard to devolution. Now, as far as the interstate supply or importation, what is levied is IGST. The IGST is the sum total of the central GST and state GST. This IGST which is collected has to be distributed between the center and the state in the same ratio of 50-50. When it comes to the question of state GST, whatever the state government collects as state GST will be accruing to them only. No part will come to the center. Whereas whatever is collected as central GST, a portion of it is given to the state government, only a portion retained by the central government. So therefore, as far as the customer is the consumer is concerned or the trader is concerned, he is not concerned whether this amount is being retained by the state government or not. All he has to do is, I am supplying the goods, I am required to pay this amount of central GST, this amount of state GST and pay it. The buyer will buy this, he'll take this amount as a credit and further resell it. So therefore, as far as the customers and traders are concerned, it makes no difference to them. As far as the government is concerned, if there is a transaction is in the nature of interstate supply, then state A, in our example, Maharashtra, will collect what is known as IGST. Once IGST is collected, it goes to the Karnataka. Then the state of Karnataka is obliged to give the credit of IGST while charging the local central GST and state GST. So therefore, this becomes credit neutral. At the back end, the center and the state will settle their amount as far as how to apportion this amount, how the credit being how the credit has to be apportioned and taken back. However, as far as the traders are concerned, they are not worried about how the back end calculation takes place.
So, Ayush, Article 269 of the Constitution of India does not allow levy of taxes on exports. However, GST allows exports with payment of taxes and then claim refund. Is this constitutionally valid?
See, first of all, whenever goods are exported, the principle is the taxes paid within the country are also not exported. Only the goods are exported. Because if the taxes are also becoming component of the price charged by the exporter in the international market, he becomes uncompetitive. So therefore, it is said that the finished goods when being exported must be stripped off all the taxes paid on the inputs and input services. This can be achieved by two ways. One, allowing the goods to export under bond or under the LUT, or pay the taxes and claim their refund. So long as ultimate result is the same, that the finished goods are exported where the GST on the inputs and input services are always given back. As far as that is concerned, whether first tax is paid and cleared, or it is exempted, or taxes are not collected at all, it makes no difference. I don't think we can say it is unconstitutional.
Ayush, Article 286 has deleted the levy of lower rate of tax on declared goods such as steel, iron, etc. Can state now increase the rate of duty on such items?
No, that clause, that section, because these goods are now covered by the GST now. So the question of state government ever living or central government living as a goods of special importance, etc., this thing will not arise. We are all fully covered by the GST now. Therefore, central tax will not apply anymore for those goods, etc. Then you don't have to worry about
that. What do you eventually feel, Madan, whether GST is a boon or a bane, whether it has resolved the things or not?
I would say it is a boon. It is the greatest boon ever given to the Indian public today. The reason is, this one tax reform is going to give the credit across, and thereby it will reduce the cost of the transactions. If you can also take into account logistic costs, and you can plan your manufacturing activities, supply chain, distribution chain properly, you can save tremendous amount for the industry. That will bring down the prices. And more important thing is, once the tax becomes transparent, when the goods are being exported from India to other countries, you are now going to compete in the international market without the local taxes. Therefore, exports also will pick up and because you become competitive in the international market. As far as India is concerned, within locally, because of the grant of credit across the board, you are now going to see over a period of time the cost coming down, sale price coming down. Competition will definitely reduce the prices. Another important thing I wanted to mention at this point of time, that
Yes.
there can be situations where the input may attract higher taxes and the finished goods may attract lower taxes. It is possible. This is called inverted taxes. In which case, the credit available to a person will be much more than the taxes payable on the finished goods. So therefore, he will always have overflowing credit. Now, this GST for the first time they brought in saying that we will give the refund of those excess amounts which are overflowing in the credit if you are not able to utilize it because of the inverted tax structure which has been created under the law. So therefore, as far as the traders are concerned, they don't have to worry as far as the inputs are attracting higher taxes or not.
So, why there was a need to introduce GST through Article 246A and not through a concurrent list entry?
Once the concurrent entries intermix, state will not.
I mentioned it at the beginning. I'll again explain.
Sir, I'm sorry to bother you. Could we stop the screen sharing so that your view comes full on the screen since we are live on the Facebook?
Sure. Oh, okay.
Yes,
Oh.
no, it's perfect.
I'm also able to see well.
Yes, yes. Because we thought that now we are not going with the PPT. So,
Yeah.
Shivam Bansal, can you please elaborate a little more as why GST was not, that is again, why was not introduced through amendment in the concurrent list?
Yeah. As I mentioned, if this GST levy was introduced by amending the concurrent list, that means center will sign its legislation, union legislation will be there, parliament legislation, state government also will legislate because they have to go and collect this state GST and central GST. And if there is any conflict or dichotomy between these two, then the central legislation will prevail. This state government did not want. They wanted very clearly that the power to be equally divided. So therefore, in fact, there was a delay in the implementation of the GST itself. So therefore, the state government said, we don't want to give a situation where we give away the power of the legislation and levy of the GST in the state governments and surrender. And at the same time, we'll get into a situation where the center may legislate in a manner where the state governments cannot do anything more than this. So therefore, they said, we will not go by the amendment of the concurrent list. We'll go by Article 246. That is the reason.
So we have Sandeep Goyal, he's a lawyer practicing out here. He wants to ask.
I know him very well. I know him very well.
He's a very bright chap.
Sir,
Sandeep?
just one second. Sir, can I ask you a question? Sir, good evening.
Good evening. How are you?
Very well, sir. Very well. It was a
You're
pleasure
doing well.
to listen to you as usual. It was complete music to me, in fact, on the subject of GST. One question which you have also touched upon, Article 279A. So this is about GST Council. They make a lot of recommendations every day. Every meeting they make recommendations. You said those are binding in nature. Those are binding. Those are not binding on states. Those are not binding on state. This is also what I also feel. But you said in case the states are not following it, those virus can be challenged. Now my question is a little different. Now, if the recommendations are binding, then of course it strikes at the very root of the constitution and basic structure of the constitution, about the federal structure of our constitution. And in case it is not binding, then what is the charm of having GST Council, and the states can again, take a different route from the recommendations which are made. So how do we reconcile this aspect?
Very, very good question, Sandeep. As usual, you always come up with this type of question, not only to me, also the courts. So I have seen your arguments also. So that's
No.
Now, Sandeep, I'll put it this way. First of all, the GST Council, after deliberations, they make following recommendation: 1, 2, 3, 4.
Whatever.
These recommendations are not binding on the central government or state governments. I make it very clear.
That's right.
However, without the recommendation, there can be no legislation by the center or the state. That's the principle. In other words, if you recommend, I may accept or I may not accept.
That's right.
However, if I want to legislate on a subject matter, on a GST, if there is no recommendation from the GST Council, this legislation is bad.
Okay.
To that extent, they are right. See, it is not as though whatever GST Council says, they should do. But if the GST Council did not say anything, can you do on your own? You cannot. Because
all right.
That's the
but they can ignore the recommendations.
They can postpone it. They cannot implement immediately, etc. They can ask the GST Council to reconsider. All those things possible. But the more important thing, why they put this particular clause is, you are right. If the GST Council recommendation become binding, then it is merely the executive. They are not the members of the parliament.
Yes.
To say that is binding, that means the parliament has necessarily bowed down to the GST Council. It is very bad.
That's right.
It will be struck down immediately.
Absolutely.
So also state because they are the represent the people. The people
That's
speak
right.
through the parliament.
It
So
can't be super
nobody,
legislature.
no 35, 25 chief ministers or the tax ministers who can say parliament should obey what we say. No, it is never. However, if the GST Council is taking a decision, taking into account the majority, nearly 75% majority, both the center and the states are putting that together, etc. This brings in the uniformity, consistency as far as the GST law administration is concerned. Without that recommendation, if the finance minister wants to do anything in the center or the state government, etc., that is bad enough. That is why even today, if you look at the very stimulus package and all this, etc., the finance minister is not in a position to give any announcement for the reduction in the GST rates and all this. She has to wait for the GST Council recommendation. Unless they agree on these recommendations and give the recommendation on this, then only the state government or the central government can legislate. So that is the delicacy as far as this collaborative.
I still believe there is some kind of gray area over there where about the power of the state legislatures to deliberate upon all these aspects, because they may deviate from them. We have seen that our past experiences, the states have been deviating.
Sandeep, we can have offline discussion on this.
That's right.
What will happen, etc. As far as the state government, suppose one state government does not want to follow.
Yes.
Or they want to do something differently. What are the powers can be done, etc. That we can discuss separately.
All right.
And we don't have to have a public.
We shouldn't hold anybody.
I know.
Thank you. Thank you so much.
Thank you, Sandeep. As Sandeep said that it was music, I also believe that a large number of participants, not only here as well on the Facebook, their GST is not a forte like Sandeep. But yes, the way you have been presenting it, it is a seamless wonder, and it's just like what we say, Saurav Ganguly was a god on the east side of playing cricket on the off side. Same as what we are hearing you on the GST. I feel the manner in which you are answering all these questions, it itself shows the volume of knowledge and depth of knowledge. The AK Singh, is GST under a threat in view of deteriorating center-state relationships? And in a sense, will this shift from cooperative to combative federalism shake the foundation of GST?
Unless, see, what happens is, all these things are put under the constitution now. Now, if any state government wants to get out of it, or does not want to participate, etc., then what will happen? Then you may bring the GST Council functioning into jeopardy. But that is where they say very clearly, 75% working with the present. If the state government abstain from there, etc., no problem. Remaining people, they will vote. If it is not there, if the 75% voting is not taking place, that proposal will not be accepted. As simple as that. The question of any state government becoming competitive and not collaborative, I don't foresee a problem like this. And if they do so, then it has to be done politically rather than economically.
Thank you, sir. P. Ramesh Kutti. Cess imposed by the Kerala state is valid for 2 years. If the Kerala state intends to continue to collect cess beyond 2 years, can GST Council impose any sanction or direct the state to discontinue the cess?
Very simple. If the GST Council has allowed the Kerala state government to levy the cess for 2 years, they can levy. If they want to levy beyond that, then without any GST Council recommendation, immediately writ will lie in the High Court. High Court will quash it. That person levy does not arise. Am I clear? Am I clear to you, sir? That is, if the Kerala government continues to levy beyond 2 years this cess without the recommendation of the GST Council, then any taxpayer can go to the court and say this levy beyond 2 years is without authorization, without recommendation from the GST Council, therefore bad in law. And therefore the court will strike it down. And therefore the question of levying the taxes beyond the 2 years does not arise.
Yes. R.R. Lomte. Charging of GST under reverse charge mechanism is necessary under this act. Is it creating complexity in the act or not?
Very interesting question. Very interesting question. Let us now analyze why the concept of reverse charge is being brought. Let us analyze that. We'll step back and ask this question. This goes back to the question of the convenience of collection. Any tax which is being collected, or the power given to the government, first of all, question is whether the event has taken place, supply has taken place or not. If supply has taken place, the levy has arisen. Then normally the person providing the supply, the goods or services must be taxed. It can happen that the receiver of the supply number can be less. Provider of services is very high, number is high. In which case, the government, why should they go after several people to collect the taxes from them? They can as well collect a limited number of people from whom the taxes can be collected. Or they're already in the tax net. For example, you take the case of lawyers. Lawyers, when they're rendering a service to a client, they are not required to pay any tax. The clients will pay the tax, so long as they're in the tax bracket, etc., etc. Why? They're already in fact. The number of lawyers in the country, the population is more than 1 million. So therefore, why should we tax all these people and then go after them, ask them? The cost of collection can be more than the collection itself. So therefore, many times the government decides that instead of collecting the tax from the supplier, we shall collect it from the end user. And this has happened in the past also. It's not as though for the first time it is happening. In fact, the old rubber cess, the latex rubber which is being produced in the rubber plantations, there is a cess to be levied, but that is not levied and paid by the plantation workers or plantation owners. It is collected from the end users, namely the tire manufacturer, the belt manufacturers. So therefore, this was questioned before the Supreme Court. In Jalandhar rubber case, the Supreme Court answered the question very clearly. So long as there is a taxable event, a levy is leviable. If the government wants to collect the tax from a different source than from the person who actually originated the goods or sell the goods, etc., it is perfectly valid. So therefore, there is no question of reverse charge being bad in law. No, these have been questioned and then already answered a long time back.
Yes, sir. So, what is the difference between a cess and a surcharge in a fiscal statute under Article 271?
A cess is for a particular purpose to be used only for this particular purpose. For example, you can education cess, automobile cess. Automobile cess is collected for the purpose of promoting R&D in our automobile. You can't use it for anything else. A surcharge which is charged over and above the existing levy can be collected by the government and can be used for any other purpose. It is not necessarily confined to one particular purpose. That's the difference between these two.
Shivam Bansal, is it possible for a state to have a different definition of supply since states have their own GST law?
States have a different, their own legislation called the state legislature. However, they cannot have a different definition of supply because the GST Council has said supply definition is this. So if you are going to go for a definition of supply other than what is going by GST Council, it is bad in law. Again, they will be struck down. Therefore, the state government are obliged to define supply in the particular manner, in the same manner where the GST Council has said, where the center and the states are all following the same way.
So, Manendra Nath Verma, can we challenge the recent retrospective amendment in the in respect of transitional credit under GST by taking the ground of principles of estoppel? What is your take on it?
I would not like to answer this question because we are actually handling some matters and it is controversial, and it is possible to take a position that we are entitled to the transitional credit.
It's perfect, sir. Haresh Nanji, whether recommendations of the GST Council can be introduced as a money bill in the Parliament?
No, recommendations are made. It has to be implemented in the form of a legislation. If the legislation falls under the category of money bill, it can come. If it is merely a non-money action, that will not come under money bill. Therefore, the recommendation per se will not get into the bill. It has to be converted to a bill to be introduced in the Parliament.
So though it's a question not directly with the GST, but as a common student of law or a young professional who is not dealing in tax, etc., could you just slightly substantiate on money bill, because this money bill part does come quite often in the newspapers and the channels. Large number of people would be interested. Let's assume who's watching on the Facebook, he might not be primarily into the taxation part, but he should be able to understand what would be the money bill, etc., and what are the subtle differences as such.
Yeah, so a very good question. See, money bill has a special status under the Constitution. It deals not only the taxes, any fiscal policies of the government is given in the form of a finance bill, money bill. A finance bill, for example, is a money bill. Give an example, basically, because that is where the finance minister gives a speech and also introduces various amendments to the various laws, etc., etc. It comes a money bill. The purpose of money bill is Lok Sabha, when it passes the money bill, when it goes to Rajya Sabha, even if it does not approve, it can return. If the Lok Sabha again says what we are saying is right, then notwithstanding non-approval of Rajya Sabha, the money bill will be still passed and the president can sign it. So therefore, the sensitivity always says that the Rajya Sabha will say these actions should not be done through money bill route. But it can happen in a money bill. Both money as also non-money can also be introduced and still comes as the money bill. But that is separate controversies going on in the court. In fact, some of the legislation made by the government through the money bill, we also question. Some comments have been made by Supreme Court judges also on this point.
So, advocate, now again that issue comes. Some people are as complex as GST. Advocate CMRP asked, the provisions of GST Act in respect of arrest seems to be against the CRPC provisions. What is your take on it?
I would say the power of arrest which has been given under the GST law is taken from the Customs Act as also the erstwhile Excise Act. The tax evasion is considered as an offence in the state and therefore prosecution can be launched. In situations where the tax evasion has been proved and the incriminated documents have been taken and the statements are properly recorded, and if the assessing officer, the tax officer feels that if the person is not arrested, it can further tamper the evidences, he may take the extreme step of arresting. But if he arrests the person within 24 hours, he has to put it before the magistrate. That is exactly like CRPC only. Instead of here, the power is given to the tax officer than a police officer, and there is only judgment of the Supreme Court saying the tax officer is not equal to police officer. Therefore, the evidence recorded by them is still admissible evidences under the court. So I would say that this has been there in provision. Power of arrest has been questioned in one or two cases. In fact, the Make My Trip case was one case where it was decided by the Delhi High Court. Under what circumstances they can arrest, what they cannot arrest, there have been guidelines been given already.
So we have Rajiv Malhotra. He is again a practicing lawyer out here. Though again, I would request everyone, though I knew him personally, therefore it's always join the chat box or otherwise through name itself. Rajiv, I have unmuted you. You can ask the question directly.
Thank you. Sir, this is regarding one question is regarding penalty and the recovery. Let's say I'm the offender. I have done some kind of fake billing, which caused the state exchequer to lose out on the GST part. Thereafter, the persons, those whom I billed, they were approached by the GST people, and they have recovered the amount from those persons to those whom I have billed the fake bills. Now, whether the recovery lies to me as well and the penalty?
I have told you in the beginning that these questions are not, is out of syllabus rather.
Right, sir. Anyway.
No. If I simply say out of syllabus, you may go with the impression that I have no answer.
No.
Now that you have asked this question, therefore I will answer this question.
So I will just clarify. I'm sorry to, though we are taking this question, but otherwise we will not take any other question beyond the syllabus. Right, sir? I just thought that while I'm doing moderating, I should also moderate the entire show, that it doesn't go the way that people start asking, then they say Rajiv has been allowed, other people are not being allowed to ask the questions out of syllabus.
Or I can answer the question offline, Rajiv. Is it okay? So that we
Fine,
get
sir.
all
Thank
the.
you so much, sir. Second question.
Is it okay?
Yes, sir. Second question. Sir, fine, sir. Thank you so very much, sir. Sir, second question. How do we divide the tax between the state and the center, and what is the jurisdiction of recovering the tax? Who supersedes whom? The state GST supersedes the center GST for the recovery, the module, the modality, or the central GST supersedes the state GST for the recovery modules?
Oh, wonderful question. What has happened is,
Thank you, sir.
Fortunately, the assessees who are to pay the taxes, central GST and state GST,
Sir.
they are not subjected by both the offices simultaneously. The jurisdiction of dealing with a particular assessee is given either to the center or by the state government. So therefore, one assessee being pulled by both officers does not arise. So this has been done administratively. Who are all the assessees will be dealt with by the center, who are all the assessees will be dealt with the state government. Once you decide that, then it is the fate, unfortunate fate or the good fate of the assessee, whether he falls in the center or at the state. The state government then will go after them and collect the full taxes, both central and the state government, and thereafter the money will be distributed accordingly. Therefore, the question of one being superior to other does not arise here.
Fine, sir. And how does it get decided that the assessee falls under the ambit of the state GST or the central GST?
That has already been announced to everybody. The people know that.
Right, sir. And second, last question, sir.
Rajiv, let's allow other persons also.
Sir, one last question, sir. It is very relevant again, sir.
No, everybody feels.
Sir, how do you feel, sir, we travel beyond PV Ramanna Reddy? Only last question, sir. How do you feel the GST will proceed ahead of PV Ramanna Reddy, sir? PV Ramanna Reddy. The Supreme Court Telangana High Court judgment, which was upheld by the Honorable Supreme Court, sir, in which Section 69, Section 70, and Section 43A, Section 41A of the CRPC and 154 of CRPC, because there is no FIR registration for the rest of the person, and then the bail, it's a judicial custody, it is not police custody. All those issues were there. PV Ramanna Reddy, can we challenge the ultra virus, because PV Ramanna Reddy interpreted the law, and the step ahead of PV Ramanna Reddy is to interpret, to challenge the ultra virus of PV Ramanna Reddy. Is it feasible, sir? It is possible. Is it maintainable?
According to me, sir, you are asking a question, you are binding me, because if I answer anyway, I can't argue otherwise in the court. I think let me not ask this question.
Sir, thank you, sir. Thank you very much, sir. Thank you so very much. Thank you, sir. Thank you, Vikas, sir. Thank you, Vikas, sir.
No issues. So it is just like saying that you are stuck between the devil and the deep sea. Which side?
Sir, thank you so very much.
Tejas, whether the levy of GST on supply can be constitutionally valid when place of supply, which is subject matter of taxation, happens outside India?
See, it is a matter of interpretation, right? You don't question the challenge, because under what circumstances the item will be considered as an import of goods or export of goods or export of services, import of services. This is determined by the rules. You may feel that it is export. If the legislation says, since the place of supply is in India, for example, intermediary services, for example, if they say so, you may not be happy, but you can't question constitutionality.
Hello.
Yes.
So, Sebastian, during the pandemic, every state is complaining that the GST due since January 2020 has not been disbursed by central government. Can it be challenged by any state government before the court of law? What is your take on that?
There is a constitutional guarantee. If the center does not fulfill the guarantee, the state government can go to the court and then ask them to make the payment. Nothing wrong. But I don't think center will allow it to happen like this. They will definitely settle down.
The provision, no. Rajiv, you can mute yourself.
Oh, sorry, sir. I'll do that.
Can restricting input credit to the extent of 10% of mismatched credit be considered good in the eyes of law or not?
According to me, not good. I said not good.
Okay, right, sir. Thank you. One Vishal Agarwal, though it's a separate issue, he says he wants to work under you. What is the way to join your office? How to apply, etc.
Very interesting question. Entry into the office is easy and difficult. Difficult because you have to go through the 3-tier process of selection. But if you get into that, after that you will enjoy the life, because it is a place where you learn. You follow the principle of earning while learning, and that is the principle which we follow. But to get into this is a difficult process. You go through the internship programs, and then selection processes and various. I mean, our partners have devised, of course, and I am also responsible for the selection of the candidates is to be taken very, very seriously. Because for me, if a person joined, I may not know him at all in my life. A young student from the law school, etc., when he applies and then when the HR gives them the go ahead, and then if he joins, from that day, because my problem starts. My problem is I have fiduciary responsibility to ensure that this lawyer becomes outstanding lawyer. So therefore, all I do in the entire thing is how to make it happen. The mentorship will be pushing under whom? What is his special aptitude? Which one will you like it? Whether you want litigation or a consulting, which subject you will like it, and what more subjects we can actually add, and how he reacts with his colleagues. So many things we constantly work on, etc. The amount of time I want them to spend on reading is enormous. And of course, correcting the drafts and various things, etc. Participating in meetings along with me with the clients, taking them to the courtroom when I argue the case. I ask them to prepare like this. We don't ask them to come to merely as a visitor, but we ask them to come to participate. And therefore, every day the learning is tremendous. And the type of briefs which we get, the quality of the brief and the quality of the mentorship will definitely make the person really a remarkable lawyer. That's what my aim is. I am trying my level best to make each one of my lawyers an outstanding lawyer. Nothing more.
Sir, I am thankful to Vishal that he has taken us to a different platform. Invariably, we take last 10-15 minutes and we are running short of time. It's upon you. People are just fascinated. We invariably complete the session at 7:30. We can go ahead, but we will not take any questions. Rather, we would like to know how this mentorship, etc., is done, so that people across the board, not only on the in the webinar itself or on the Facebook. How do you believe, like one person has asked, as a young consultant, how can one improve my skills of giving written opinion? He may not be under the veteran mentorship of the LNS. So how he should do, how he should read, what is your take? Let's take these 10 minutes for sharpening our skills on that aspect.
Come again, the question coming?
Sir, the question is, how can one improve the skills of giving written opinion once one does not have a mentorship, like let's assume LNS? Because the legal opinion in black and white is something else. Oral opinions can always do.
No, even oral opinion also is as important and as firm as the written opinion, sir. There is no difference. As far as I am concerned, I don't take oral opinion lightly. I take that same seriousness. I have only one question to all of you, sir.
Sir, could we, I'm sorry to bother you. Could you just push backwards, because while we go in the Facebook, your face is being cut. Right, it's perfect now. Yes, sir.
I must tell you today our firm may be about 400 lawyers. But there was a time in the year 1985 when I started, I was alone. I was having the clients. I was not having any mentor. I was doing myself. So therefore, it is not impossible for individual lawyers to excel. But what is important is hard work and never take chance. And always ensure what more I can do to this client. Whether I am giving opinion which is convenient to him or correct. If you ever get into a situation where the client wants his opinion, therefore I give it, etc., it down the hill. It is raised to the bottom. Never fall into that. Never fall into that. Always ensure that you give the correct opinion, not convenient opinion. But amount of time you have to spend in doing research, unlimited, regardless of the fee the client will pay. If that fee paid is going to be a factor for you to research in giving the response, I will not rate you as a good lawyer. That is one aspect, the fee. After that, the fee portion should never enter your mind while researching on a particular product. And this way, if you can maintain highest ethical standards, never fall for any shortcuts. Remember, even today, the shortest distance between 2 points is still a straight line. All crooked lines may look attractive, but they are not shortest. The easiest thing to do in life is to defend the truth. If we can maintain these standards, because you have a long-term vision, you can never fail, sir. Of course, you may have to work about 18 hours a day minimum. There are days I work for 48 hours, 72 hours non-stop. And I never complained to anybody. I enjoyed it. There's the joy of doing something phenomenal. And therefore, I do not see because a person does not have a mentor and therefore he will give his quality brief or opinion will be lower or no, not necessary at all. You are the best teacher yourself. All other mentorship, etc. is additional to that. But you are made yourself. That is what the God has made you.
So now the question track on the chat box has changed. Sir, can you share your daily schedule to enable us to have an enriching experience? I just say that they are taking a cue from Mahabharata. One may have direct guru like Arjun and another may have a guru like Eklavya. So today we are fortuitous enough that we have a guru in the shape of a virtual platform where we can have the insights from that.
I will give it's not a secret. What I do is not a secret. But how many of you will be able to do, I do not know. I get up in the morning around 3:30 or 4 or even earlier. And I finish my seeing the early mails and messages, what instruction I have to give, etc. I do it in about 45 minutes. Around 4:45 or so, I'm in the park. I run for about an hour and a half. Nowadays, I am not able to run because of the restrictions and the lockdown, etc. And I come back and take shower and then do my pujas till around 7:45, 8 o'clock. And 8 o'clock, I'm in the office. I do not know when will you go back. Maybe 10 o'clock, 11 o'clock. Normally, I go to bed around 12 o'clock. But before that, I ensure that I read at least 10 judgments of the subject. And before I go to bed, I ask a question. Am I a better lawyer today than yesterday? Did I learn something new? Did I mentor something? Did I argue some difficult cases? Did I give an opinion which is very difficult to the client? If I get that answer, yes, I sleep well for 3 hours. That's all, sir.
Yes, it looks quite challenging, but they all say that easy paths never make you reach to a good destination. Good destinations are always challenging and they have to be accepted with passion and this thing. So another that, like you said, that you read 10 judgments. It's my personal take. Nowadays, some judgments are itself running into 300, 400, 700 pages. So how do we cope up with those 10 judgments along with the case law which you have to prepare as well as the case law? What is your take?
Yeah, if the number of pages are more, you read in 2 days. You keep in mind that when I say 10 judgments, it is the average size of 30 pages. If it is 500 pages, etc., obviously you will do it in 2 days' time. Or on a Sunday, you sit down and read it completely, take notes, etc. So you don't have to worry that I must read 10 judgments of 500 pages, etc. No, I am not saying that.
Now I understand once one who works or works under the ages like you, then why the word impossible becomes I am possible. So I can with vouch say that LNS people, when they work, they turn impossible into I am possible. So Vinay Kumar Jain says 3 things what a good practitioner should learn, and what are the 3 tools according to you which make him a better lawyer, and what should he do to do that?
Why only 3? There can be 300 things. No? Why only 3 to make him a good lawyer?
Probably he's taking cue from that when it was given the power that you can take 3 steps. So Dharti, Partal and onwards. Yes, sir.
Yeah. I mean, I would say never put a restriction on your mind for thinking. Keep your antenna up always. Ideas come at any point of time. Second, you can train your mind to do 2 things simultaneously. It's possible, so that it will include productivity. I am talking of my personal experience. Third, purity of thought and clarity of mind is an important aspect in lawyering. And it is very easy to say, but very difficult to practice. At any point of time, that should be the yardstick for you. not to falter from their steps. And last but not least is that the joy is in giving and sharing. The joy is not in accumulating. When I say sharing, it is not merely the wealth or the money. It is sharing of your time, sharing your experience, sharing of your joy, and sharing of your sorrows. All those things you need to spend time with the juniors to make them really outstanding. And this joy, it will never end. There is no measure to this joy.
So, what you said, that all things which look easy, it's always difficult to follow. As I read in one of the books, it said that probably somebody's mic is on. Kindly could you mute yourself? So, as I read somewhere, that it was said that if to do was as easy as to say, then poor would have lived in palaces and horses would have flown. So, G. Balaji, how to blend law, language, and facts to become a good lawyer, and what one has to do constantly to focus to improve his knowledge and other acumen.
Honest?
What one has to constantly focus to improve all these things. Blend of law, language, and facts, because we all know that the lawyer is a combination of knowledge of law, placing of facts in the proper thing. And as a lawyer also, I felt that the opening statement before the court is very paramount. You may finish or make good or perish your case only because of the opening statement with the court.
No, you are absolutely right. I think what Balaji is it? Her name, the person who asked the question. Yeah, whoever asked the question is asking the right question. You see, the first statement you are going to make about a matter before a court must come out in a manner is simple, straightforward, and to the point. It can happen only when you have complete mastery of the brief, facts, and the law. Then only you can simplify in simple terms, say that this is the point. If you are not clear, I am telling you, you will never be able to make a simple statement which is directed to the point. So I agree with you that you must assimilate all the facts. You must know the law point of it. You must know what exactly you are going to say and say, yes, in this particular thing, the short question for consideration, my lord, is this. And many times I have told the judges, sir, please don't open your file. Just listen to me for 5 minutes. And then we can tell you the relevant pages. There are situations where I have reduced 1,500 pages brief into a single page, a diagram, a line diagram, and say, use only this. It contains all what is contained in the paper. Let us now discuss this. It has worked. But simply, I'm telling you today, if you are asked to write an essay for 30 pages, it is easy. If I ask you to write an essay for 1 page, you will struggle. Why? Because putting all the ideas into one short paragraph is not easy. And that can come only when you have complete mastery of the facts and the law.
So point well taken. According to you, for a good lawyer, he should have 3 things: concise, incisive, and precise. That is what I could gather from you.
Sir, I cannot say better than you.
No, not at all, sir. We are all learning from you. I am more fascinating, and I am feeling that rather we should have one talk, how to become a good lawyer, how to do mentorship. One question, like one has been posted on the chat box. It says that you said that you didn't have the mentor, and then you still grew better, and then you ultimately groomed many people. 400 people taking in one shot, and that through a 3-tier system. It's
not one shot, over a period of time, not one shot, over a period of time.
Sir, that is why itself Rome was not built in a day. It took years and years. It takes years to make anything, but it takes moments to destroy. Coronavirus is an example of that. So how, he says, how can one learn the mentorship, etc.? How to develop a mentor and how to develop the patronage that somebody can take actually cue how to improve himself, how to sharpen the tools?
Simple, sir. You make one decision that this junior coming before me, I must make him better than me. Problem solved. Problem solved. I want you to remember, I don't know whether many of you would have heard the conversation with Dronacharya and Duryodhana after Bhishma fell to the bed of the Arabs. And Dronacharya was in his chamber, and Duryodhana asked him, "Sir, you are happy today. Is it because you became commander-in-chief?" And he replied, "Sir, you will never understand me. Tomorrow I am going to fight Arjun. I am going to use all my weapons to destroy him, defeat him. But he is going to defeat me in the battlefield tomorrow because he is a better warrior than me. He is going to vanquish me tomorrow. And I am going to tell the whole world, I have produced a student who is better than me." You follow this, sir. Your student or your junior can never be your competitor. Even if you should applaud, why should you worry about it? So therefore, the mentorship, everything is only to ensure that you give everything to him, regardless of the fact that he's going to be with you or not. You want to go practice on so, no problem. Bless him. Nothing to worry about. As far as you are concerned, your job is to train him, give him all the support so long as working with you. Never pull back. It doesn't make any sense.
Sir, point well taken. It is. I am reminded why there's a famous doha which says, "Guru Gobind tau khade kaake lagu paye, balihari Guru aapki Guru Gobind ji bataye." That once you are faced with the Guru and the God, that one should always first give respect to the Guru because Guru has shown the light towards the God. The point well taken. Now, only last question, sir. Again, on the profession of law, what, like you said, that 1,000 page, you make it in a concise in a 1 page. Just that bullet point, that main Guru mantra, how to do about that?
There is no way of doing it. So teaching yourself over way. You have to practice this. Practice, practice, practice. Today, I am telling you, when I dictate a note, when it comes to me from my secretary, I ask a question. Could anybody else would have done this draft better? If I get an answer, yes, probably yes, I tear this, I redo it. So therefore, the more attention you give to the facts and the law, over a period of time, things will settle down. You will be able to precisely state what the exact issue in a 1 page or even less than that.
But still, that bullet points, how to make that bullet actually to work. What is the key to that? Practice, I understand. Again, back to Mahabharata, I am reminded that somebody asked Bhim that how can you eat the food in the dark? He said to his brothers, Abhyas, Abhyas, Abhyas. That is practice, practice, and practice. But still, what could be the key for that?
And I have no other way because you're self-learning. There is no other way. And even a junior comes with a bigger reads where it is wrong, etc., or it is too elaborate, you tell him, no, this is not the way, do it like this, do it like this. It comes.
Sir, the way we are just sailing through, we do not know how time is flowing. I'm just reminded, time and tide wait for none. But once it is in a good company, you always enjoy that company. Sir, another question, because I also have an associates in my office. How do you ultimately try to instill that confidence? How do you help them to read better? Because everybody is now in a shortcut, wants to have a shortcut towards the success without actually going through the rigors and rigor modes of the tough times.
Such people have no place in my office. No shortcuts in our office. No, out. It has to be a sustained work. And there is no way a person can achieve success by some other groups or by hook or crook. No. The only way is the long route. The only way is to work hard. The only way is to get correct. So therefore, I have no mantra to give to those people who want to have a shortcut to success. I don't know, sir. I just don't know. So therefore, you're asking a wrong person this question.
Okay. Sir, another question. We have done lot upon that how the lawyer should do. How this mentorship, etc., should be done as a guru or somebody who is running his own office or a firm. What is your take on that? How should he further the art of delegation of and disseminating knowledge to them should be taught?
See, the message has to go down the office. It is not enough if you are a mentor and the others are not. Every partner in the office must be told very clearly that when a junior asks a question, you are supposed to answer. Forget the junior, even an intern. When you're working in our office, learning something at the time, they come and ask a question to a partner. Unless he is arguing a matter or preparing something, etc., he should leave the work, clarify to the person, give the answer, and then. So this message has to go that knowledge is not the monopoly of anybody, it is meant for dissemination. Once that is clear, then your writ rights completely in the entire office here. You don't have to worry about.
So it is just like what they say, each one plant one. So as you grow these saplings, the seeds become plants and plants become tree according to you.
Yes.
So that it has been a wonderful session. It's just like, I just wish if the time was with us that we could continue getting these insights. But now we can only make a request that tax, it was always looking taxing on the face of it. But once you have a person like you coming on the platform or anywhere else, it is seamlessly very good to learn. They say there are only three processes. On this webinar, I'm always saying, first there has to be a yearning for learning, and then only there can be earning. Sir, I will ask Sapant here, who has been closely working with the Beyond Laws team. He will propose a vote of thanks, but on any convenient day, how to do about the law, tools of advocacy, or any other topic, you just like, not on tax. Tax, of course, it's always enjoyable once it comes from a person like you. It is just to say, when you see a good person, he can essay any role, or a good lawyer can just seamlessly come into any effort, and it is a seamless effort.
Because
yes,
I want you to know one thing. You know what is tapas? I don't know what is English translation for tapas. I don't think we can have any particular word for tapas. A tapasvi does the tapas with a hope. One day he will have a darshan of the God. That is his ultimate wish. And he does it. He does it years of tapas. In the heart of heart, he knows it may not happen. It may happen, may not happen. He is aware. Yet he does it. Over a period of time, he starts enjoying doing the tapas. The journey itself is so interesting. If the destination happens to be good, nothing like it. If it is not happening, doesn't matter. I enjoyed the journey. So I do the same thing, sir. I don't expect anything yet what is going to happen. But every day morning, I'm at a tapasvi sitting in the office, working. There is no Saturday, there is no Sunday, there is no holiday, etc. For me, I enjoy the work every day.
Point well taken. They say for any hardworking lawyer, of course, like you, there's every day is a Sunday, because every day we have a sun on the day. So it is a Sunday for everybody. But the question is, Sunday is not for a leisure day. It has to be studied. One has to be just like a newspaper news channel, 24/7. According to you, one has to continuously read. So Mr. P.S. Anand says that after 3 years of practice, he was feeling that he's not in the right career. But after hearing you, he feels that he has been given some certain insights. I will add one more thing. It is for large number of participants who are doing that. It is just like they were undergoing, especially during these dark times. We have shown them that little window, that little candle, which actually helps them to sail through.
I one thing to say.
Yes, sir.
Tax laws are not simple, whether direct tax or indirect tax. It is very complicated, highly contested, several amendments, judgments, overruled. We take judgment 1922, 1919, etc. Plus, you must know the accounts, you must know the technology, you must know the business. It is very, very difficult. The entry barrier is very, very high. I accept, I concede. But that cannot be the reason for lawyers not getting into this. Because the demand is so much. Please, I beg you, work hard. Devote 1 year, 2 years as sabbatical. Get over this entry barrier. Thereafter, you see what the fun is.
So that is why they say one is lonely on the top, and I can gauge why LNS is lonely on the top. But lonely on the top, you get the best views. Say once you go to the Mount Everest, the view from the Mount Everest is entirely different than what you see on the basic thing. Otherwise, if the view on the top would not have been good, people wouldn't have gone to the hill station to enjoy the sights.
I
So
must,
while
tell
being
you,
on the top,
I must tell you one thing. I have
Yes.
not gone to Everest, but I have gone to North Pole and South Pole. And I enjoyed the nature at its best. So therefore, those are the places where people don't go at all, but it is what place visiting. And you get time to yourself, and then you can ask the question, part of nature, what exactly it is. So I am not scaled Everest, sir. I want to tell you. I am always sea level only.
So that is a comparison that once you compare that if you are somebody on the extreme top, that I was just reading an article today that the gut feeling and the guts one has to do. It is said that when one has to go to the moon, at that point of time, the Edwin C. Aldrin had been trained that he had to jump and he had to become the first man. But he had certain fears looming in his mind. And at that point of time, Neil Armstrong just jumped in and he created history. So I was just reading that sometimes in life, you just get a fraction of a second. And then that is the key of success. What is your take on that?
I agree with you.
So thank you. The question and answer session would continue. I'm just feeling as if it is. You said that for 18 hours you could study. So thank you, sir. And we would like that you should come on a platform on us where we can have the insights as a lawyer, as a team, how one has to grow. Because eventually, as you said, sharing is caring. And especially during the pandemic and the dark days, if we start disseminating knowledge, and this is the entire platform. Frankly, before lockdown, we never thought that we would create something like Beyond Law, and we were talking something with law and beyond law. Let's assume now we are talking beyond law. We have Sapan Dheer, and Sapan Dheer will propose a vote of thanks. And thank you, sir. It was a wonderful session. Just before we part, I would like your son to come because he has been acting and facilitating all this program.
Yeah,
because I've always seen that whenever we are.
He has stepped out now, sir. He has just stepped out.
So he has just acted like the Aldrin. He could have been made us Neil Armstrong, but just convey a thank you to him and thank you to the entire LSS team who have made us learn better things. Over to you, Sapan. Sapan, just propose a vote of thanks. Vote of thanks will, a 2-minute vote of thanks here does not show that it is actually there. That ring within the mind will continue for a wonderful session which we had. Thank you, sir. Over to you, Sapan.
Thank you, Vikas ji. Thank you, sir, and for wonderful session. We have learned a lot from you, and I think that lot of learning process is just left also. We want you to come here again and again, so that we can learn so much from you. And I just read about you, sir, that this firm, your attorneys, that it's a vast experience of professionals specializing in corporate sector and commercial laws and all that, bank arbitration, banking law, commercial litigations, competition, corporate, custom, taxes. And I think that nothing has been left from you, sir, that you have continued in your profession. And I have gone through your other articles also, that it's a lot of learn from you. Simultaneously, today also on this webinar, one has enriched his or her knowledge from you on this wonderful session. Thank you, sir. Thank you. And we wish you to come again on some other issue. And I, on behalf of Team Beyond Law, Mr. Vikas Chatraji, Ratanji, UILS, we all thank to you for wonderful experience shared by you, sir. Thank you, sir. Thank you very much.
Just last word. Only one last word. Somebody has written that you deliver lectures in Sanskrit. One last quotation in Sanskrit before we part. He has written that you deliver lectures in Sanskrit in Balaji Mandir. So just give an insight of a Sanskrit shloka which can just be the dose for the entire day to be cherished.
Okay. Shraddhaya deyam ashraddhaya deyam Shriya deyam Viya deyam Priya deyam Sambhita deyam Adhayati te karma vidigitsa va vritti vidigitsa bhasyat. I'll stop. If you go on, I'll stop.
Great, sir. Thank you.
The only explanation to that, because majority of them, for them, put it, though Sanskrit is related to our Sanskriti, but sometimes one feels that it's just an explanation and then we wrap it.
This is the portion from Taittiriya Upanishad. It is giving the joy of sharing, joy of giving.
Thank you, sir. And tomorrow we have again one of your partners, Mr. R. Parthasarthi, principal partner in your firm, who will speak on free and fair international trade under WTO. Tomorrow, do connect with us on this webinar. We start tomorrow at 5 rather than 6. And sir, we are thankful.
I must tell you, the brilliant lawyer. And on the subject he's going to talk, is the real master. There's nobody to beat him or compare anywhere near him in this subject in India. With that level. And I asked him to talk. I think he will go to enthrall you. Not what I talked.
So, thank you. It is just like we have seen today's Virat Kohli playing. Tomorrow we will have Rohit Sharma. Both are treat to be heard and watched. Thank you, everyone. Stay connected, stay blessed at home, and stay healthy. And now start reading also. Let's take the cue. What the seedlings have been seeded in the minds. Thank you, sir. We will all try to come to the expectations on your side. Thank you, everyone.
Thank you.